Corporate Insolvency Resolution Process. Complete procedure from admission to successful implementation of a resolution. Hello everyone, welcome back to our channel RR Legal Talks. We have another channel RR Corporates. In this video, we will discuss the complete journey of CIRP from filing of an application before NCLT to successful resolution or successful implementation of the resolution plan and dissolution of the monitoring committee. So complete process of CIRP. So let's begin with the occurrence of default. This is the stage 1. The entire CIRP starts when a corporate debtor CD commits a default. This is the starting point. Default may be related to financial debt or operational debt or corporate guarantee, any other debt recognized under the IBC. So once the default occurs, the creditor, maybe operational creditor or financial creditor, becomes entitled to initiate CIRP. Second stage, filing of CIRP application. Once default is there, then application will be filed depending upon the nature of the debt, whether it is a financial creditor or operational creditor. Filing financial creditor, file application under section 7. Operational creditor, so first he has to issue demand notice under section 8. Thereafter file an application under section 9. Corporate applicant also can move application under section 10. So the corporate debtor itself may file an application under section 10. This is stage 2. Then we'll come to stage 3, admission by Honorable NCLT. So the adjudicating authority examines the existence of the default, completeness of the application and supporting documents and proposed IRP. If satisfied, then NCLT admits the application. This is the beginning of the CIRP. Then next stage 4, moratorium. Immediately after admission, NCLT declares moratorium under section 14. So during moratorium, advantage, no recovery proceedings on the company, no execution proceedings on the company, no suits filed on the company, no foreclosure, no transfer of assets of the company, essential services will be continued, and moratorium protects the corporate debtor as a going concern. All these benefits for corporate debtor continue as a going concern. And the next stage, that is stage 5, appointment of IRP, Interim Resolution Professional. Simultaneously, NCLT appoints an Interim Resolution Professional. IRP takes the charge of the management. Board of Directors stand suspended. Management vests in IRP. Next stage, stage 6, public announcement. Within the prescribed period, IRP issues public announcement. The announcement invites financial creditors, operational creditors, employees, government authorities, other creditors to submit their claims before IRP. Next stage, stage 7, collection of claims. IRP receives claims from banks, financial institutions, operational creditors or employees or government departments and home buyers and other stakeholders. So then stage 8, verification of claims, because once claims received has to be verified by IRP. Verifies supporting documents, agreements, loan accounts, then interest calculations and security documents. Therefore, the claims are admitted or rejected with a reason. Then constitution of COC, that is stage 9. Constitution of COC, that is Committee of Creditors. After verification, IRP constitutes a Committee of Creditors, normally only for financial creditors having voting rights. Okay, special cases and we will discuss. Then once the COC is formed, then the next stage, stage 10, first COC meeting. Important decision. What are important decisions? First COC, confirmation or replacement of IRP. So appointment of a resolution professional, whether he will continue or new, will be recommended. Appointment of registered valuers, appointment of legal advisors, appointment of transaction auditors. So this is the first COC meeting. Then next stage 11, appointment of resolution professional RP. COC either confirms the IRP or appointment of another insolvency professional as RP. So the RP thereafter manages the CIRP. Next stage, preservation of assets, takes custody of assets. RP protects the records, preserve the books, maintain business operations and supervise the management. The next stage 13, appointment of professionals. RP appoints registered valuers, legal counsels, transaction auditor, forensic auditors, technical experts and process advisors. So this will be done by the appointment by the auditor, appointment by the RP. Then the next stage, preparation of information memorandum. So RP prepares the information memorandum. What it contains? Financial statements, assets, liabilities, litigations, contracts, employees details, licenses details, operational details. So complete detail, information memorandum, IM. Next stage, valuation. Two registered valuers will determine fair value and liquidation value. So these values are kept confidential. The next stage, invitation of expression of interest, EOI. RP publishes invitation. RP publish the invitation. Interested investors submit their expression of interest, EOI. Next stage, eligibility verification. So applicants are examined under section 29A. Only eligible applicants proceed further. Then issue of provisional list. RP publishes provisional list of prospective resolution applicant, PRS. After provisional list, then objections. Applicants may submit objections if any. RP finalize the list, then issue the final list. So eligible resolution applicants will receive information memorandum, virtual data room access, request for resolution plan, RFRP. Then due diligence. Resolution applicants inspects the assets, review legal records, analyze the finances of the company, conduct technical study and visit the factory. Then the next stage, submission of resolution plan. Applicants submit their resolution plans, EMD, earnest money deposit, affidavits, board resolution, funding details, financial proposal. Then the next stage, examination by RP. RP, after receiving the resolution plans, he will examine on IBC compliance, CIRP regulations are followed, mandatory contents and documentation. Incomplete plans may be rejected. Next stage, evaluation by Committee of Creditors. COC evaluate financial offer, then visibility, feasibility and viability. This is the test. Then implementation capability. They also will see the funding. So based on this, COC evaluate the resolutions. Then there is another process, if adopted, challenge process. COC may conduct Swiss challenge, online bidding, negotiation, revised bids. Next, selection of successful resolution applicant. So highest evaluated resolution plan is selected. Then letter of intent. RP issues LOI, letter of intent. Successful resolution applicant accepts the LOI. The next stage, submission of performance guarantee. Successful resolution applicant submits the PG, performance guarantee, within a prescribed timeline. COC approval. Next stage, resolution plan approved by at least 66% voting shares. Then filing before NCLT. RP files application. before Honorable NCLT under Section 30, subsection 6 for NCLT's approval. The next stage, approval by NCLT examines Section 30, subsection 2. NCLT examines CIRP regulations, compliance certificate. If satisfied, resolution plan is approved. Then resolution plan becomes binding. After approval, resolution plan binds corporate debtor, financial creditors, operational creditors, employees, government authorities, successful resolution applicant SRA. Then next stage, monitoring committee. Many resolution plans provide for constitution of monitoring committee. Generally consists of representative of COC, resolution professional, successful resolution applicant, financial creditors, independent member wherever applicable. So the next stage, functioning of monitoring committee. So monitoring committee supervises payment to creditors, then equity infusion, then working capital, business transfer, then share transfer, then compliance with the resolution plan, then the timelines, then conditions precedent, then regulatory approvals. Then after that, implementation of resolution plan, resolution applicant pays the creditors, infuses equity, arrange the finance, takes management control and restart business. Next stage, release of performance guarantee. After completion of implementation, payment to creditors, satisfaction of obligations, performance guarantee is released. Dissolution of monitoring committee is the next stage. Once implementation is completed, monitoring committee records completion, then committee is dissolved. Post implementation of corporate debtor continues under new management, then former CIRP comes to end. If resolution fails, then what? No resolution plan is approved, or approved plans fails, NCLT may order for liquidation. That is the next stage, liquidation if required. Liquidator is appointed, assets sold, realization distributed under section 53. So corporate debtor eventually dissolved. So the conclusion is, the corporate insolvency resolution process is not merely a legal proceeding. It is a structured mechanism. It is designed to preserve value, protects the stakeholders, then revive distressed companies, and maximize recovery for creditors, then save employment, then promote entrepreneurship. Understanding the entire life cycle of CIRP from admission to implementation of the resolution plan and dissolution of the monitoring committee, and if essential for every organization or professionals, this is a very important, this is essential video. Thank you for watching. If you found this video useful, please like, share and subscribe for more practical videos on IBC, CIRP, resolution plans and liquidation, company law videos, SEBI, FEMA and corporate compliance. Thank you.